this webinar. As you will know, Coram Claims is hosting a series of webinars, and we're inviting people to make a donation to the National Emergencies Trust coronavirus appeal, and the details of that will pop up courtesy of Rakaya in the comments box as we go. The format of this afternoon is that Alison and I are going to talk for about 20 minutes each. There will then be a time for some questions. What we're asking is that you put your questions in the using the chat device, and we'll round up some questions as we go to answer at the end. We'd be grateful if people didn't try chatting verbally. I hope you can see on the screen the handout, and Rakaya will be sending that out to anybody who's joined this meeting. I know from just looking at the pictures I've just seen of some people and the names that we've seen, that there will be people here who've got a great deal of experience, and I recognise at least a couple of you who will have actually done some of the cases that we'll be talking about. There will be some of you for whom court of protection work is an area which you've decided to explore because you're at home and this popped up into your email. Whatever your motivation, we hope you find the next hour of interest. I'd like to start by reminding ourselves of the principles which are set out in section 1 of the Act. And there are 3 principles to do with capacity which appear in the Act. The first is that a person must be assumed to have capacity unless it's established that they lack capacity. And the second is that a person is not to be treated as unable to make a decision unless all practical help to do so has been taken without success. And the third is that a person is not to be treated as unable to make a decision. The position of the last point, of course, is a huge protection for many of us in our daily lives. In terms of the way that this works, the importance of the presumption of capacity it is something which is not new to the Act. It was in the common law. But the Vice President of the Court of Protection, Mr. Justice Hayden, comments that it notes that it's the only presumption in the Act, and it's a huge protection for someone's autonomy. It's a jurisdictional issue. Unless a person lacks capacity, the Court of Protection can't make a decision by way of an order authorising action for a person in respect of their welfare or their property and affairs. Although there's been some recent case law on emergency applications, and it's been decided that the court may still grant declarations in anticipation of loss of capacity. The other aspect of this about capacity is it applies to everybody, not just High Court judges, but those delivering care at home, to a relative, or in a care home. You know, somebody trying to make a decision as to whether to wash an elderly man in a care home who doesn't want to be washed and put to bed at 7 o'clock in the evening, or whether you're a surgeon who's looking to insert an IUD while performing a cesarean section. And the court and other people can act to make interim decisions where there is reason to believe that P, that is the person who's the subject capacity in relation to the matter. Now, the Code of Practice is an important supplement to the Act. It provides evidence, slightly different to Section 7 codes of guidance, but it is a code of practice which provides evidence which the courts can take into account when determining what interests, whether somebody has capacity, or in any other consequential litigation. And it draws attention to the fact that a number of reasons why people might question a person's capacity to make a specific decision, somebody's behaviour, somebody else's report, or the fact that they've got a previous history of being unable to make some types of decisions. But that presumption is important, and giving you the quotation from a decision in the Employment Appeal Tribunal, decision of RBS and AB. In that case, AB attended a tribunal hearing into assessing her damages in a disability discrimination claim, and she was unable to recognise her lawyers. She was unable to answer any questions, and her lawyers decided that she couldn't give evidence. Nevertheless, they decided they would carry on without getting an assessment of capacity. And the question was raised in the Employment Appeal Tribunal about whether that should be the way forward. The Employment Tribunal had actually relied on the presumption of capacity in refusing an application for an adjournment for an assessment. And the president of the Mr. Justice Swift, sitting in the Employment Appeal Tribunal, said presumption of capacity is important, but it cannot be used to avoid taking responsibility for assessing and determining capacity, because that would be to fail to respect personal autonomy in a different way. Because if a litigant lacks capacity, an assessment of capacity should be undertaken, because if they don't, there is nobody, they're not able to effectively participate in the litigation. So yes, it's a bastion for autonomy, but it's also the gateway to protective best interest decision making. And the decisions that, one of the reasons we feel that capacity decisions are so difficult even now, 15 years after the Act came into force, is because of the tension between that autonomy and paternalism. The Code of Practice reminds everybody that the starting point is that somebody has capacity to make the specific decision, and it sets out a series of questions you might like to ask yourself if you're involved in assessing capacity, or you're trying to analyse a capacity decision set out before you. And those questions are set out in the Code of Practice in 4.36. Now, in order to lack capacity, you have to be unable to make a decision for yourself. And that has to be because of an impairment or a disturbance in the function of the mind or brain. And it can be permanent, it can be temporary. But you can't just establish it because of the way a person's age or appearance, a condition of his, or an aspect of behaviour. The decisions on whether somebody lacks capacity are made on the basis of balance of probabilities. The importance of the fact it's a particular decision was reaffirmed by the Court of Appeal in the recent decision of B against the local authority, which is going to feature later in Alison's talk. But they drew attention to the fact that underpinning the Act was a decision that it's a functional approach, that it's an assessment whether an individual is able, at the time when a particular decision has to be made, to understand its nature and effect. And as opposed to looking at the outcome, which focuses on whether an individual's decision is inconsistent with conventional values, or is one with which the assessor disagrees. Yet, whilst that is the aim of the Act, there are a number of problems. One is the fact that identifying what is the question, what is the decision. Mr. Justice Cobb, a man who was once described to my wife when she was a solicitor as an educated sort of geezer, is a person manages to conflate care and residence decisions, resulting, separates them out so much that he reached decisions which are inconsistent in the view of the Court of Appeal on questions of where somebody should be cared for and where they should live. Mr. Justice Hayden, in the decision Tower Hamlets against NB, which attracted a huge amount of adverse publicity last year, was actually considering the question, not the general relation, not sex between A and anybody in the world, but A and his wife, and or more particularly the wife and him, and because there was no other realistic option being proposed. So you have to look at the particular question, and it's the central to looking at when you've got the right question, then you've got to understand what is the information relevant to the decision, and can that person understand the information, retain the information, and use or weigh that information, and can they then communicate the decision? But they're not. This isn't an abstract. The Act is not abstract about this. It imposes an obligation on people to use language which would be appropriate to enable someone to understand. They might need simple language, they might need visual aids, that they may need to have aid memoir, they might need to have it written down so they can go back and have a think about it. Justice Peter Jackson, in the case I did, you gave a short separate order which said the judge decided you must live in this house. The judge decided you must have care. And that was to be pinned up on the lady's wall. So she remembered that a judge, she'd come to court and the judge had decided what was going to happen, because otherwise she would forget. And it would help to try and reduce her distress. The other important aspect is people have to understand the foreseeable consequences of deciding one way or another, or not making any decision at all. Now, all of that underlies this proposition, which I think is often overlooked. An assessment of capacity is not an evaluation of the decision the peer is taking, but of their ability to take the decision to do or not do something. So it's actually about process. The code of practice sets that. And one must avoid, and I love a quote, ensuring that the tail of welfare doesn't wag the dog of capacity. That is, you don't start from the premise, what would be a good outcome for this person? And if they agree with it, they've got capacity. And if they don't agree with it, they lack capacity, and you override it. That's not the way it works. People are allowed to take bad decisions, and many of us do all the time in our daily lives, without any question of our capacity, except possibly from our spouses. The code of practice sets out at chapter 3 ways in which that process can best work to ensure that people have all the relevant information and have it explained to them in a way that they can deal with. And I've touched on some of those things already, and they'll be there in the handout. An illustration of this comes from a personal injury case, O.H. and Craven. And as the judgment says, rather to the surprise of everyone, one of the consultants in the report said this person has the capacity to make these decisions about managing their finances. And that the quote I've given you shows that he was vividly evident, he could understand the information, able to use it, weigh it up, able to communicate the decision using non-verbal communication and typing on his phone. Now, he had a cognitive disability, that wasn't in dispute. He had impaired communication skills, as a result of brain injury, but nevertheless he could make a free and balanced decision. People should have been less surprised if they'd considered what had happened when he'd had a conversation or had been sitting there while his mother and his solicitors had a conversation. He joined in the conversation by typing into his iPad, "I can make my own decisions." He had followed the conversation and knew exactly what it was about, though nobody had actually asked him at the time. And there is these causal links, the causal link between what is the decision, and can it be taken, and if it can't be taken, is it to do with the underlying impairment? It involves some quite nuanced decisions. SFF is a decision that Alison will deal with later. But in that case, Mr. Justice Cobb had to deal with the questions of different types of memory, because SF's dementia meant she had what's called semantic memory of her husband, so she could interpret his moods and appearance when he approached her, compared with episodic memory, which left her vulnerable to other people because she couldn't contextualize their non-verbal communication. And the National Institute of Clinical Excellence in their decision-making guide reminds people that where there is executive dysfunction, for example, following a traumatic brain injury, that is frontal lobe damage, structured assessments capacity for individuals in this group by way of interview may need to be supplemented by real-world observations of the person's functioning and decision-making ability. And that was illustrated in the case in which Mr. Justice Cobb referred to that in Sunderland and AS, where the assessor actually changed her opinion after hearing AS in court, and she heard the social worker's evidence. Now, obviously, there is a difficulty when people gather their evidence from carers, because carers and social workers are often the people who've asked for the assessment because they think the person lacked capacity. So it is quite important to, when one's looking at these decisions, to look and see whether there is look around, look at the sources of information, and look at whether the decision was taken on a 45-minute interview, or, and in current climate, over a video interview with an elderly lady who may or may not be very good at the technology if you're following the current guidance about how to do capacity assessments in the time of the pandemic. In decision of QJ and the local authority, it was said that an elderly gentleman who NG refused to accept a tube for feeding and drinking, and he was refusing food and drink. And the treating doctor who gave his views about this said this is a common feature of this illness. Justice Hayden was quite concerned about this, and he was satisfied that you can't merely, he reminded everybody that you can't merely establish lack of capacity by reference to a person's condition or an aspect of his behaviour. The fact that that is common in the that type of illness that the gentleman had was no answer. It's an aspect of QJ's behaviour, including his reluctance to answer certain questions. That doesn't mean he was unable to do so. Being stubborn and difficult doesn't make you lack capacity. Those are my words, not Mr. Justice Hayden's. But what was clear was that QJ was making a choice. So on the balance, applying the presumption, Justice Hayden was not satisfied that NG lacked QJ didn't lack capacity. Though I do find it slightly interesting the last line I quoted, it's potentially significant, certainly interesting. The agreed medical consensus as to the way forward accords exactly with what QJ himself expresses. Potentially a classic example of if you're actually able to agree the plan, you have capacity. Now, the lack of understanding of risk, or inability to weigh up the information, can form part of a capacity assessment. So that's quoted in B in local authority. I find that quite worrying because effectively, whilst a pattern of decisions may indicate that someone isn't very good at reasoning, it is dangerous, I would suggest, although the Court of Appeal clearly disagrees with me, to reason from the fact that people have made bad decisions, that they therefore lacked capacity in those decisions, and this reinforces you that you lack capacity in this particular decision. My view is that if you're going to rely on other examples of poor decision making, you need to look at whether any of those poor decisions might have been different if different information had been given to the person, or they had been taken in different circumstances. Fluctuating capacity is a difficult topic at this time because the Act deals with a specific decision at the time it needs to be made. If you can postpone a decision because somebody lacked capacity, for example, they are put into a coma because of surgery or something like that, they're unconscious, can you avoid taking the decision at this time? If you can't avoid taking the decision, you may need to take a decision which is the least invasive decision that can be taken at the time, and least enduring, so that when a person regains capacity, they can reverse the decision if they want to. But there is a group of decisions where which are a real problem, where a person loses capacity periodically, and certain decisions need to be taken both when they have capacity and when they don't have capacity. In Sherwood Forest Hospitals, NHS, P had a history of paranoid schizophrenia. She was actually utterly cooperative with her treatment plans up until the time that somebody said she was going to require some surgery. She'd actually sought medical help and a diagnosis. And partly as a result of the shock operating in conjunction with her paranoid schizophrenia, that triggered a view that a delusional belief that she didn't need to have the operation. And that manifested itself in the language of religion. Effectively, she said, God will sort the problem. But the thought was that she would actually regain capacity. And if she had capacity, she would have wanted the treatment. So there was a very delicate balance to be struck there. In CDM, Mehdi had a problem with her diabetic management and a number of other decisions, all linked to a personality disorder. Mr. Justice Cohen made a set of decisions about a variety of domains, and they're set out in the slides below, one of which included her diabetic management. The Court of Appeal refused leave to appeal on everything apart from the issue about diabetic management, and then decided it wasn't going to resolve the question and remitted it back to Mr. Justice Newton to make a fresh decision. Mr. Justice Newton came to had a different approach to Mr. Justice Cohen over the same issue. the way Mr. Justice Cowan dealt with it, he said, well, treatment in this context, in this case, relates to ability to manage our diabetes, manage control of blood levels. And the problem was there will be some occasions when she makes appropriate decisions. And Mr. Justice Cowan said, I accept Dr. Seary's evidence that when making appropriate decisions, she has capacity. When she's making manifestly inappropriate decisions, she lacks capacity, which seemed to radically change the way that capacity decisions were made to the exact reverse of the functional test that I referred to earlier. So when matters came back before Mr. Justice Newton, he analysed it in a different way. He analysed it in terms of whether things were macro decisions or micro decisions. And he took the view that you have to look at the individual, the combination of the particular type of decisions and the particular individual taking the decisions and the particular reasons why those decisions might be difficult for that person to take. And he wasn't prepared to agree a single test for all sorts of illnesses. But he analysed the diabetic management, which as a global decision, and on the basis it was a global decision, which from time to time CDM would not be able to take. He declared that she lacked capacity to take the decisions about her healthcare. That means there are times when she has capacity, and if she refuses, the order suggests that she is able to be, her wishes are overruled. This must place practitioners in a very difficult situation. If she is clearly able to take the decision on a particular day to refuse, for example, to take her insulin. But that was how Mr. Justice Newton resolved it. He just said, this is a major decision, and I'm going to make a single declaration. That approach, coincidentally, because of the way these decisions were taken and reported, would have found favour with Sir Mark Headley, where he took the view that decisions which are single isolated decisions, such as making a will or power of attorney, you may have fluctuating capacity, and as long as you take the decision when you have capacity, that's a matter for you, and that's fine. The court won't interfere. But when your decision is made up of a variety of smaller decisions, then and repeat decisions, then you may lack capacity. He calls that a longitudinal view. So whether it's a longitudinal view or a macro question may determine how somebody with fluctuating capacity is to be treated. Now I'm going to pass over to Alison now, who's going to deal with issues to do with the relevant information that you need or P needs in order to make a decision to inform a capacity decision. Thank you.
Thank you, Nick. Good afternoon, everyone. Nick, I think you need to close screen sharing on your computer for me to be able to do it on mine. Thank you.
Done.
Thank you. Right, everyone, I hope you can now see what should be slide 31, entitled Relevant Information. Just to reiterate, all these slides and these notes will be circulated to all of you. I hope that doesn't mean now you'll immediately leave. And secondly, I just wanted to thank Nick, who in fact is largely responsible for doing these slides, and I'm very grateful to him. Now, what I'm going to talk to you about is really the more detailed approach adopted in respect of some of the cases which the Court of Protection is dealing with. In particular, I'm going to deal with the specific issues relating to residence care contact, capacity to consent to sexual relations, and also social media access. I'm starting off this part of the talk really with the heading relevant information, because this is really one of the keystones in any Mental Capacity Act assessment. Nick referred to it, of course, early on in the talk, because it's specifically referenced in the statute in section 3. And what you want to be really checking whether you are reading a capacity assessment to check that it's adequate, it's good enough, it's compliant, or if you are someone undertaking those types of assessments, is really to ensure that when P is the patient, the person who's the subject of the application, when they are being assessed, that they are being provided with the relevant information so as to enable them as much as is possible to demonstrate their capacity. Now, this is a case, the KK versus STCC from 2012, a decision of, as he then was, Baker J, relating to an 82-year-old woman who had Parkinson's disease, vascular dementia, and left-sided paralysis. She had been placed in a care home. She wanted to return home full-time to live in her bungalow. The professional and expert evidence was unanimous that she lacked capacity to make decisions about her residence. But Baker heard oral evidence from her, and he rejected that unanimous professional and expert view and took the view that ultimately the local authority had not displaced the presumption of capacity. And what he had to say in terms of what is the relevant information, the approach to a Mental Capacity Act assessment, is very important in terms of reminding us what needs to be in place each time we look at one of these assessments, although undertaken. The key thing is that it's inappropriate to start with a blank canvas. It's not really about discussing with P options in the abstract. What P must be provided with is concrete, detailed options, because it's only then that their ability to weigh up those options can be fairly assessed. I mean, whilst of course a frivolous example, if you're deciding between two different options, whether that's a trip to Wales or a trip to the Maldives, if you know that one of those is in a backpacking hostel and one's in a 5-star hotel, it may influence your view, and they are factors to weigh up. And what was key in this case, and is going to be key in any cases which you deal with involving in particular residence and care, is the importance of making sure that in this case, KK, was given full details of the care package that could be made available were she returned home to live in her bungalow. So it wasn't just simply about whether she should be in the nursing home, which implicitly had all of it inherent within it, all of the day-to-day 24-hour care and support and assistance, but also the fact that if she returned to her bungalow, that sort of assistance could be made available to her. And because that had not been provided to her during the assessment, the details of the care package, Baker took the view that therefore she hadn't been offered a proper assessment which enabled her, to the best of her ability, to engage in the decision-making process. Baker then goes on, and I'm highlighting this slide, that also what we have to be very careful about is that when we come to undertake or read Mental Capacity Act assessments, we don't attach inappropriate weight to certain factors based on our view as to what is in that person's best interest. This point about the tail of best interest wagging the capacity dog, and what that means is really, in essence, that we are approaching matters as a local authority often might in a risk-adverse way. What that translated to in this case was that for the professionals, they obviously felt that great weight should be attached to the security and the comfort of a residential care home that could meet KK's needs round the clock. But of course that was that's the prism that they looked through, whereas actually for her the more important thing may be in fact the comfort and the emotional security she got from being in her own home. And that's why when you're reading capacity assessments, you need to just keep checking that that sort of paternalistic, protective, adverse risk approach isn't finding its way into the capacity assessment, when actually it's not about what the assessor's views are. It's about, as Nick said, the process of the assessment. Then Baker went on to also look at, in relation to the relevant information, it's not KK in this case. You don't have to understand every aspect, every detail of the different options, of the factors involved in the decision-making process. But you have to be able to understand the salient, the headline factors in looking at what are the pros and cons of each option. And Baker went on to highlight, and you know, when you're dealing with cases involving older people who wish to return to their own home, really what he said was that for many people there is an immeasurable benefit, and there is truly no place like home, and the emotional strength and secure which they derive from being at home, surrounded by familiar reminders of past life, cannot be underestimated. And actually that's, I think, really trying to step into the shoes of P, which ultimately is what the role of the judge is, to look at it completely from their landscape, from their perspective. And for many older people, actually, and I'm sure Nick would confirm this, that is such a benefit from them that really, that's why you have to really look at whether that is an option or not. And finally, in this case, one of the particular areas that the local authority highlighted as a risk was that KK would forget sometimes to eat and drink, and she would call Lifeline. I mean, I think she called it over 1,000 times in 6 months in the beginning of 2011. And they relied on that to suggest that that meant that she lacked capacity. Well, Baker wasn't persuaded about that. He didn't feel that necessarily calling emergency services in the middle of the night meant that she lacked capacity. And that was, if you like, a trespassing into the capacity issue by concerns about support plan and actually best interest making decisions. And what he then went on to say was here that in relation to using Lifeline, in relation to use women forgetting to eat or drink, that could be addressed by leaving notes, by providing possibly people to sleep in for the first time, for the first few nights that KK went home, to remind her not to call Lifeline and to drink. And therefore, ultimately, what Baker concluded was those weren't reasons why he was persuaded that KK lacked capacity. And as I said at the outset, he did not feel the local authority had displaced that presumption. Now, this next quote comes from a case of B versus local authority, Court of Appeal decision, a decision of Cobb that was appealed. This is a very important decision. I recommend that you all read it because it sets out a number of useful principles, but this is one of the guiding ones from it, where it refers to what's called the list. That squarely comes back to the issue of relevant information, because what has happened is that a number of judges have attempted to produce a list of what is the relevant information applicable to certain issues. So a relevant list of information for capacity to consent to sexual relations. In this case, it was a list of information in relation to access to social media, and that the relevant information which should be given to P when you assess his or her capacity in respect of that issue. And what the Court of Appeal have said is that it did not have a difficulty in principle with the idea of judges creating those sorts of lists, which really are to assist practitioners, but they are guidance and they are to be expanded or contracted as is appropriate and relevant to the circumstances of P. Because ultimately, any relevant information, any assessment of P is to be bespoke, because P is an individual in every case with individual characteristics and value systems. And that means that when you come to look at the list, of course, it has to be altered and tailored to their specific characteristics and individuality. Now, we then set out the cases which apply in respect of each of the potential issues that you might be coming to the Court of Protection to seek assistance and decisions upon. And then what I'm going to do now is just move on to some of the cases which deal with those specific issues, really the most common type of issues, and then the ones which are now developing and you're going to be bumping into more and more as the years progress. LBX is a decision of Mrs. Justice Tice. It is now some 7 years old, but still is entirely applicable and good law. I'm not going to read through in detail these individual slides, you will get them. But in essence, what Mrs. Justice Tice did was, in relation to residence, care and contact, set out what is the relevant information that should be provided to P whenever P's assessment of capacity is undertaken in respect of those issues. So on this slide, you can see 1 to 9. They are the parts of relevant information that should be communicated to P within any assessment of her ability to make decisions about where she resides. Mrs. Justice Tice then goes on to explore what shouldn't be taken into account or expected in terms of P's capacity, an assessment of capacity. So, for example, when one is exploring with P her ability to make decisions, her capacity to make decisions about where she lives, it is not necessary for those to include her capacity to understand how much that's going to cost or the value of money, what the legal nature of a tenancy agreement or license might be. And of course, many of us will have clients who, whilst they have capacity to give instructions, to generally engage in a whole host of issues, may not be able to understand the difference between a tenancy agreement or a license. And the whole point of the Mental Capacity Act is to place P on a par with someone else in walking in the streets in Cardiff or Carlisle, so that we are not expecting more and we're not setting the bar too high in relation to P's ability and assessments of P, because that would be discriminatory. As I've said, we've dealt with residents in this case. This is now the relevant information that you should have in front of you in relation to care. And again, a little helpful recording of what is not relevant information, because of course what that means is, if you see those sorts of components and aspects in a mental capacity assessment, that is a red flag, that it is expecting too much, it is setting the bar too high, and it may not be a fair and proper capacity assessment which you and the court can rely on. Because of course there is a presumption of capacity. The Mental Capacity Act, in my view, is about empowering. It is a platform for P, and it's a safeguarding element to ensure that we are satisfied, fully and properly satisfied, forensically satisfied, that the court has jurisdiction because P lacks capacity before we trespass into their personal autonomy. Finally, in this case, Tice then sets out the relevant information in relation to contact, and also the matters which don't need to be taken into account. And all of what I've said before obviously applies to that. Now, I'm then going to move on to look at capacity in respect of the use of social media and internet. This is a case REA decided at the end of last year, again by COB. It came with another case, the case of REB, which he heard both of them in the space of a week. REB went up to the Court of Appeal, REA didn't, but a lot of what COB said in REA was considered by the Court of Appeal in REB and was held to be sound. And the point that I took you to earlier about the list being guidance is that came from the Court of Appeal's view in REB and its decision making in respect of that. Now, in the case of A was a 21-year-old man. He had a learning disability. He was a compulsive user of Facebook, and whilst he used Facebook, he would very regularly share very graphic photos and videos of himself with other users. He had begun to access extreme pornographic sites. There was a real concern about him accessing paedophiliac sites, and also that ultimately his inability to read warnings about what he should access, what he shouldn't access, what was lawful and what was not, was going to mean that he would find himself within the criminal justice system. What COB was asked to decide, first of all, was whether P's accessing social media and internet use was a form of contact, because of course we're using the internet now, we're using Zoom, it's a form of contact with others. But Cobb said no, it's not a form of contact. It is a completely separate category and I will treat it as such. And that decision has been upheld by the Court of Appeal. And partly the reason for that, in reaching that decision, was again this important sort of fundamental keystone that we do not want to limit autonomy unless it is necessary and justified. And if one set restrictions in relation to media use, social media use and the internet use, they may then translate into restrictions in terms of personal face-to-face contact, which may not be so necessary. And this is the reason why Cobb came to his decision as to why he felt there were particular and unique characteristics from social media networking internet use which distinguish it from other forms of contact and care. I won't read that out to you, but it's a helpful aid memoir which I think translates into a number of different jurisdictions. What Cobb then went on to do is to set out the relevant information that must be shared with P in any assessment of P's capacity to understand, retain, use and weigh, which of course is the central element of any Mental Capacity Act assessment. And this is what, therefore, you are looking to explore with P in any assessment of his capacity to understand whether he has capacity or not. And it's these sort of headline 6 points that you are looking to see. Is there a degree to which P is able to understand these points, this information? Is he able to retain? And is he able to use, weigh them up, engage in a decision-making process which evidences that he is able to attach weight to part of them or understand some of them. Cobb then went on to just provide some useful interpretation of what he meant by the relevant information. And again, I'm not going to repeat it here. We don't have time for that. But it's there if you have a case in this area for you to read, just so you understand really the parameters of it. What actually is the thrust of the meaning of the relevant information that you're going to be exploring with P. And finally, Cobb was asked to include, or was asked whether he should include within the relevant information that is assisting the assessor of capacity to weigh up whether P does or does not have capacity, the extent to which P should be aware that using the internet could have a psychologically harmful use on him, because of course some images that you may see may in fact be very, very distressing, may lead to confusion, may lead you to have a distorted belief about a whole range of different things. But in fact, Cobb rejected that as something which needs to be taken into account, because again, it would be elevating the need for P to take into account information that many users who have capacity of the internet don't take into account. They have a whole, millions of people access the internet watching things that are at risk to psychologically to them, and they are still able to do it. And this is just a slide, an excerpt from the Court of Appeal's decision in the case of VB, which you remember I discussed with you just a little earlier, in which it was content to hold up Cobb's relevant information, and just also highlighted the point that even if the court and the judge determines that in this case B did not have capacity to access social media use, it did not mean that he would not use it. It would just mean that there would have to be a proper best interests, risk assessment, welfare assessment of what could be put in place to safeguard him whilst he was using it. I'm then going to finally move on to sexual relations. This case of London Borough of Tower Hamlets versus NB is one of the leading cases on it by the Vice President, Mr. Justice Hayden. Here, interestingly, he compared the Mental Capacity Act to the Children Act, in that what he says is there is a distillation of principles, the need for proportionality, and that actually you're looking at factors which then you pull together ultimately to ensure that you have an accurate and a purposeful Mental Capacity Act assessment. He also highlighted the danger of what's called conceptual silos. Silos, and that term is something that came from that appeal case with Cobb in WeBe. And ultimately, what that means is that if you take too narrow a view of capacity in one area, it may lead to a conflict, really, in declarations of capacity in respect of others. So, for example, in the case of B, Cobb had concluded that the woman in that case had capacity to make decisions about where she should reside, which was with a man who presented a significant sexual risk to her of sexual exploitation, but made declarations she lacked capacity about having contact with others, including him, and having sexual relations. And what the Court of Appeal said is there can be an overlap in all of these areas, and we don't shy away from that. And in my view, that's just simply a realistic recognition of the fact that this is not a straightforward area. This is the relevant information that is included within any Mental Capacity Act assessment of P's ability to make decisions about sexual relations. So this is what needs to be explored with P. Whether P understands the mechanics of sex, what are the reasonably foreseeable consequences, the opportunity to say no and to choose whether or not to engage in it, health risks, and the use and how you use a condom. So they're very practical things. And this is also, I've highlighted because in my view, it's obvious, but it's worth restating that it's been highlighted time and time again, but it's very clear that consent, i.e. the consent is not part of relevant information. It goes to the heart of capacity itself. That's a fundamental inherent thing in assessing capacity, that the person knows that they are able to say no, and they can say no. Two helpful cases on this issue I just highlight there, in terms of where there is capacity to consent to sexual relations, but concerns about a particularly unsafe partner. That's TZ, and obviously the Hayden case, which I referred to before. Now, finally, I'm going to finish with this case, case of SF, just earlier this year. It's a very important case because hitherto the court's decision has been that when one looks at capacity, capacity is decision specific. And so it has ordinarily been understood that when one is assessing capacity in relation to contact, that is contact with others, not with a person, and contact and capacity in relation to sex is sex with a person, not with that person. What this decision, again a decision of Cobb, Mr. Justice Cobb, was looking at is whether or not SF had capacity to make decisions about contact with her husband, and whether she had capacity to make decisions about having sexual relations with her husband. I mean, she was 45, they'd been married 25 years, but there had been a deterioration in her functioning and a change in her personality, which had led to concerns being raised as to whether her capacity had dissipated. Interestingly, Cobb heard evidence, expert evidence from Dr. O'Donovan, an adult psychiatrist, who was clear that SF lacked capacity to decide on contact with strangers and people who were unfamiliar to her, but did have capacity in relation to her husband because, and this is the point that Nick touched on before, that she was able to retain sort of inherent memories of him, which were which she had accrued over the 25 years, which involves sensation, touch, the sensation around her relationship with him, all of those aspects of it, but couldn't particularly remember what was called episodic memory, which was specific incidents with particular details. And because she was able to have this very clear understanding of her husband, that pre-morbid knowledge she had of him, that meant that the psychiatrist took the view she did have capacity in relation to him. and similarly for similar reasons in relation to sexual relations. So what this case said was that in fact you could make a declaration that she had capacity in relation to an individual, even if it was the case in relation to the world at large they didn't. And that's a very new decision. It's a decision which may be controversial in some areas, but is very much one which some may say is welcome to enable there to be a promotion of this woman's personal autonomy and her ability to have relations with her husband, because if there was a declaration she lacked capacity, then it would be the case she could not, because the court cannot sanction, could not sanction sexual relations in that case. Finally, I've set out at the end 10 top tips when you're looking at capacity assessments. I just put those down as an aid memoir. It is not exhaustive, but it is just a sort of a headlining of the points that you want to make sure are you are considering in your mind when you are reading an assessment of capacity. Thank you. I think I'll hand back to Nick now.
Hello. Thank you very much, Alison. We've got some time for some questions if people would like to pose them. Add them to the chat and we'll deal with them. We've had a question from Pete, or an observation from Peter Edwards, who probably knows more about this than most. His firm was involved in Sir Mark Headley's decision in PKW. But he raises this question, that little weight is attached to the prerequisite of the second principle. Where is the evidence of the attempt to communicate in a way that P could relate to? Many capacity assessments are unlawful. And just for those of you who don't want to scan back to remind yourself of the first slide, the second principle is that a person is not to be treated as unable to make a decision unless all practicable steps to help him do so have been taken without success. And I agree with Peter. It seems to me that that is a repeat failing. One sees it with capacity reports where you've got it just simply says, I discussed with Mrs. Smith what she felt would be the difficulties if she went home. Something, something bland like that. And you're asking somebody who is frightened and somewhat confused to discuss concrete practical steps. And then you get it says in the report, Mrs. Smith was unable to consider what difficulties there might be. Now, if you don't have the discussion with her, what about, how are you going to get up the stairs? You haven't got a bathroom downstairs. Are you prepared to use a commode? What about, and start putting practical things and see what the reaction is, and sometimes revisit them. And it seems to me one of the problems that often arises, these assessments are done and people don't revisit them to see what people think after a period of reflection. You're asking somebody to take make life-changing decisions on a first meeting with very little rapport established, and so it really doesn't deal with these practical steps not being taken. Often you might need somebody who is familiar sitting in. Maybe you don't want the family sitting in, because the family are all sitting there giving their elderly mother a warning, don't you dare say you want to go home, mother. Look, that might be a really major practical problem in getting somebody to reflect on it. Something which I have used recently, or we've been using recently in some cases, is where the person has been able to go home, or a video has been taken of their home. Because in one recent case, the family had, as soon as mum had gone into the care home, they nipped in and ripped out the 1960s kitchen and the bathroom and everything that was familiar, and put in something new because they were looking to sell the house. So when mum says, I want to go home, their case was, mum won't recognize this as home. Well, we had no idea. It was two lots of guesswork. It was the daughter's guesswork and our guesswork. So the answer was, we had some photographs taken, and what became clear was, oh, but that's my garden. And what was important to her was the fact she could see her garden. The fact the kitchen was different wasn't a big issue for her. And so we took another person, we took him to his home. And what was so extraordinary was he was videoed in his home, pointing out, oh, I bought that with my wife, and we did this, and we did that, and that's a photograph of so-and-so. And they blossomed and were much more relaxed about being able to tell you what things were. And a third person, we had a similar situation, who walked into the house, took one look at it and said, I don't want to stay here, and walked out again. We'd all booked, everybody been booked to the cab had to be called back rather hurriedly. We'd all been expecting she'd be in her home for an hour and a half. She took one look at it and said, I don't fancy living here anymore. Now there were all examples of somebody who's able to better participate as a result of some care and some tailored thought as to what might be important and what might prompt them to say things. And of course, the final thing I want to say about this, well, perhaps Alison can be having a question too, but if the final thing you might want to say about this is that if you're frightened, and you don't want to stay somewhere, and you're frightened that if you say, oh, I'll need lots of help, they won't send you home. So the answer is to say, I won't need any help at all, which goes back to Mr. Justice Baker's point. If somebody's told, you can have help, the help will cover this, but it won't cover that, how are you going to cope? Then somebody may answer those questions better. But if they're frightened that if they say the wrong thing, they'll sort of fail the assessment, and they won't be allowed to go home. So they say, I won't need any help. Whereupon they fail the assessment because the social worker actually says you need help, so you fail. So Peter's absolutely right about that, and Peter's made another observation in the message to me that he just, and I want to point this out, the person who's got to be the onus on getting the capacity assessment right is on the decision maker. And if you have any doubt about that, look at section 5, which makes it clear that, you know, the decision maker, before they do something, has to have satisfied themselves about whether somebody lacks capacity and looking at questions of best interest. So if it's not somebody else's decision, it's the care home manager, the social worker, the surgeon, the judge. And if you are saying, for example, somebody lacks capacity to litigate, it might be you. So you have got to, the onus is on that decision maker to get the assessment right. Okay, question 2, Alison, do you want to?
Well, I was just going to add to that. I mean, I know we're running out of time and you're all being really very patient. But I mean, I just think whenever you look at a Mental Capacity Act assessment, I think it's the duties on all of us to interrogate them properly.
Yeah.
To make sure that we do feel that they have provided people the best possible opportunity to engage with it, to express their views. And it really is startling sometimes how there can be so much disparity between social workers or people who work with people who think more imaginatively about how they can be engaged, how they can be encouraged to communicate. And often family members will have useful suggestions about how that can be done. And I did a recent case where my solicitor, we were acting for P, had gone to visit P to ascertain her wishes and feelings. And really it was a very difficult, a very unproductive meeting, but she went back subsequently at a better time with P's son, and it was a completely transformative interaction. And so I think that we all have to be on our guard when we read these, not to simply take them at face value, but to really dig deep and think what more can be done, and all the things that Nick has pointed out. The next question that's been raised is the problematic issue of remote assessments, remote capacity assessments in light of the current public health emergency. And I must admit, I have a real problem with the idea of remote capacity assessments. I mean, it may be that there are some absolute urgent assessments that are required. But it seems to me that when you are dealing with people who are vulnerable, who often have communication difficulties, with whom you have no rapport often, then the idea that you are going to have a valuable and a valuable capacity assessment which maximises their ability and opportunity to engage with it, I think is going to be largely impaired. And therefore, I think that unless it's absolutely necessary, I think they must come with a serious health warning. Nick, what's your thoughts?
Well, I don't understand how you can establish rapport. I mean, we shouldn't make an assumption that people are poor with technology. Once it's not surprising that it's been we've seen a growth in the issue of access to internet issues being fraught ones in capacity assessments and best interest decision making. It's extraordinary how skilled many people with learning disabilities are about using their phone to access the internet. So we can't assume that people are able to do it. But it seems to me that it's, when one's assessing capacity, one's looking at other cues, which you just can't pick up on the postage stamp view, as it described in the case recently by the president. You can't do it. If somebody's sitting there fiddling with their hands, or are they looking nervously out of shot to see whether they're getting the right answer from the person, or are they just wondering are they listening to whether it's somebody's calling out in the corridor at their care home that it's tea time? I mean, you can't pick those things up. They are all those distractions, all those other things that go into it. The other person may not be able to hear you or see very well, may not be able to make out your own facial features to try and read the cues. It's not a conversation. And it seems to me that if one's trying to establish, for example, whether somebody's got capacity to litigate, it's really very difficult if you can't start discussing with them what the issues are by reference to, for example, the papers, or you may want to say, well, a quote, and the person might feel comfortable if they've got it in front of them. There's a reason why people come into your office. There is a reason why we try and have a bit of private time at court with our clients. And it's not just because we don't want to be with anybody else. It's because everybody values that interaction. Litigants in person are finding court protection and other hearings really very challenging. And judges are finding it very challenging. And that leads to the final observation I wanted to make about this linked issue. There's a premium in the court of protection, premium value placed on involving P, even at court. And if you're locked in a care home and your only access to court is by way of a Zoom, a shared Skype screen or Zoom screen, and you're 85, it must be utterly bewildering. The answer is you're not really involved in the decision making. You're not involved at all. So I don't think you're in. So I think they will come back to haunt people. I think a lot of those assessments that are being done at the moment are going to be treated as nothing more than interim, and they will all be revisited unless in the most absolutely staggeringly obvious case. So.
So does anyone else have any more questions to put up on chat? Or if not, I think we're, oh gosh, I'm sorry, we've overrun our hour, as is always the way when barristers start speaking. But if you have any questions that you want to raise, anything following up, then obviously feel free to email Nick or I, and we'll be very happy to deal with any queries. Yeah. But thank you very much for your attention on a late afternoon. And it was very nice to see so many familiar faces.
Okay. Thank you very much, everybody.